Well, good evening, everybody. It must just be Paul by himself. Absolutely not. No, I've got Travis here with me. And sorry, we were just having a little bit of a blather just before we kicked off there. So, because it's been a while since I saw you, but well, first of all, welcome.
Some were blathering,
yeah,
or havering more than others, but
yeah,
that's true.
Yeah.
We had a bit of a blather.
Yeah, yes, and
it's good to see you. Yeah, it's been a while. I think we had a quick video chat maybe in August, but
we did, yeah.
it has been a while. But we've stayed in touch by other modes of communication, and I've been catching you've been doing a lot of pre-recorded presentations, premieres, I don't know what you call them, but rather than live format. And I've been catching those, and I still always look forward to your tutorials on height. You had one last week, really interesting, explaining the arrangement of a standard. But I always enjoy those.
Yeah, it was the Atholl Highlanders, which is the Atholl Highlanders is the only privately owned army in Europe, and they're there to protect Blair Atholl Castle.
Really?
The Atholl Highlanders, yeah.
They're a private army.
Yeah, well, officially private army. I don't know. I'd need to do a bit more research into it, but they're about 700 years old, and Blair Atholl, the castle, they're there to protect whoever the monarch of the Glen over there is,
Back 150 years ago, going on now, when we were fighting, or 250 years ago, when we were fighting, to remove the tyranny and the scourge of King George.
Yeah,
we hired the Hussons,
right,
to come in and help us, and then, of course, the French are always willing to engage with. It involved the king. So, but I did not know that they were a private army. Hussons were the only ones I was familiar with. But
yep. Yes, that was a long time ago. But yes, I think there's still a certain animosity between the certain parts of the UK, i.e., the English and the French, whereas the Scots and the French have always seemed to get on pretty well. So,
have you all made amends with Ireland? Cromwell was pretty tough on the Irish.
Yes, I think sometimes these things can take a while, can't they? This sort of peace, truth, and reconciliation. They can take a while.
Yeah,
it's
so funny over in the UK. I mean, certainly going back to at least 1044, and the Battle of Hastings.
Yep.
And now we're 2020. Vast spans of time, whereas over here our relative time clock goes back to late 1600s.
Yes.
And you all have good history, clear history going back at least 1600 years, 1,000 years before that. So we forget. Much longer timeline over there.
Yes, I'm particularly interested in the history of music, and of course, one of the main pioneers when it came to the introduction of, for example, do, re, mi, fa, sol, la, ti, do, and he also did one or two other things to do with music and music learning, was a 6th century monk called Guido di Arezzo. So that was 1400 years ago that he went to the Pope and said, this is my new idea, and the Pope said, that's fine. Everybody's going to do that from now on.
Well, do people know your family's history on bringing the piano accordion to the UK? Have you shared that story on any of your videos?
My granddad, although he was born in the UK, in the Gloucestershire, he moved back to Italy when he was only about 4 years old, and then never learned to read or write, but grew up as a sheep farmer in the hills between Rome and Naples, where there was, wolves were a problem, and he learned on a little melodeon type thing. But by the time he came back to the UK when he was about 18, he was quite proficient. So he used to busk, and before too long, him and his brother, my great uncle Nick is Jim Capaldi's father. Jim Capaldi, that was the drummer with Traffic and had many big hits. They were the Capaldi brothers, and it was actually just before the breakout of the war, because my granddad had been so successful with his Capaldi brothers' entertainment at variety halls. My gran was a tiller girl, a dancing girl. Hona was paying my granddad £2 a week, which was more than an average weekly wage, just to endorse the Hona accordion that he had, which they'd given to him. And the plan was, spoilt by the war breaking out, but the plan was to have a Capaldi music shop in all the major cities in the UK. But of course, the war scuppered all that, so he ended up buying a tipper truck and helped to build an American Air Force base just outside of Evesham.
Wow.
So,
yeah, when I was pulling something up, Capaldi brothers popped up. This was months and months ago. I thought, oh my word, Paul's the offspring of a flying trapeze circus act. And then, I clicked the link and I went, oh, they brought the piano accordion to the UK and popularized it.
Yeah.
So that's great. We have Lawrence Welk, but
yes, yeah, and for all accordionists that know who the greatest of all time was, know that was actually Charles Magnanti, and obviously the name Magnanti, obviously Italian background, but he was born and lived in New York, but he was without doubt the greatest of them all. Although a lot of people say that Pietro Dero was the daddy of the accordion, but again, that they and Pietro Fuzzini, all these guys I mentioned, that they all ended up in America, and a lot of Capaldis ended up in America because they were trying to get to America from Italy, but people like my granddad got as far as the UK and never went any further. So
it's not bad either. No. So I found this case. I was talking to Julie the other day. He checked weekly in Wisconsin. They announce opinions that are scheduled to be released a few days before they are released. And talking with her, and she mentioned, I just checked the list and Stephen's not on it. And so I was curious, and I just pulled up the list and I saw this case, State versus Garcia. And I talked about that case earlier on in some other interviews with people, and in the context that it's one of the very few cases the District 2 Court of Appeals in Wisconsin, where Stephen's case is pending, had granted oral argument in the case.
Yeah.
It's very, very rare in a criminal case. But they had granted oral argument in this case, and I noticed that. And what I was looking at it at the time for was I knew people were going to ask. The final brief had been filed for Zellner's response. I knew people were going to ask, when can we expect a decision?
Sure.
And Zellner had requested oral argument. State that doesn't need oral argument, but if they get oral argument in the case, it's going to dramatically impact and things are going to happen and how quickly. And of course, the pandemic came in too. But
yeah.
If I was looking at it for that, well, there is a case to have oral argument. And so when I saw the list that Julie had mentioned, Julie Pom Pom, I think everybody knows.
Yep. Julie,
yep. Worked with KZ.com. She tracks all of the pleadings and whatnot and posts them up there. So you can follow along the case that way. But I looked it up and I went, oh, there's that case. I wonder what happened. I didn't see any notice of oral argument. So
Sure.
Then I read the case in a whole different light, looking at the substance of it and whatnot. And I was actually, it doesn't have any legal, much, if any, legal similarities. The issues are completely different than Stevens. But I was encouraged by what I saw in that opinion. And so I got in touch with you, and I thought we'd talk about that a little bit, just go through the opinion a little bit and why it renewed my optimism about Stevens' appeal and my optimism about the composition of the court currently and this particular appellate court. And I think everybody can draw a little bit of optimism with it. Or people may think, my parallels are crazy. I mean, I find parallels in a lot of things. People don't, as you know.
Well, the thing is, though, what I was asking you just before we came on air, of course, was, as a defense attorney, any kind of win for the defense is probably something that you applaud. But as you pointed out, it's not the battle, it's the war that you need to win.
Yeah, at the trial level, the win that has finality to it is when you hear the words "not guilty." If it's, it could be a mistrial because the jury hung up, which means you were able to convince people there was reasonable doubt. 12. So there's the possibility of having to do it all over again. If you lose and have to go up on appeal, as we've seen, there's just many, many, many battles to stretch off ever, and you can win battles and lose battles. You could, win all of them, win all of the battles like Brendan, but lose the war at the, at the final battle, the en banc hearing.
Yes.
And be denied a battle, if you will, in the, the highest court. And so it's, you're only as good as your last trial. And when you're in the post-conviction process, it's very difficult. It takes a very special breed of person to be good, consistently good throughout an entire career. Post-conviction work. There's very, very, very few of them.
Before I forget, by the way, I must thank you for a long time back. I mischievously set up a sort of a question, which was, if you needed a defense lawyer and you could choose anybody in the world to defend you, who would you go for? Knowing full well that obviously, because of the case, a lot of people would go down there. And you mentioned Dennis Reardon.
Yeah, question specifically was, post-conviction.
Yes. Yeah.
As opposed to hiring somebody for trial.
Yeah.
And I did say Dennis Reardon. He became the central lawyer in the West Memphis 3 case. He's based out of California. I've known of him for years and years prior to that. He is probably the best of the best in post-conviction cases. And then, you did have that mischievous comment.
Well, as a result of watching some interviews of Dennis Reardon, I came across Brian Stevenson.
Mm-hmm.
And I watched the film Just Mercy literally within the last week. And that was absolutely brilliant.
Yeah.
I think Brian Stevenson is definitely becoming my favorite lawyer. He's up there with Vic Fazell, definitely.
Yeah.
Present company accepted, of course.
Thank you. Thanks. I just had an exchange with Vic, friendly hello or something. May have been on a attorney forum. Mm-hmm. He seems to be doing good. He's doing a lot of stuff on decriminalizing marijuana in Texas or legalizing it.
Right. Yeah. Now that guy, I was incredibly impressed. For a for an attorney to do what he did, and then to put up with what he had to put up with, and come out the other side. Albeit probably got 1 or 2 deep scars from the experience, but he's still there. He's still battling, isn't he?
Well, yeah, and then he sued a couple of the media outlets in the Waco area afterwards, and got a $20 million verdict for libel, defamation. I don't know how much he collected; it doesn't matter, but he got vindicated that way. I know he got a fairly sizable chunk of that, if not all of it, and he's been doing quite well ever since.
Walter, we could sit here and chat about all this stuff all night long, but I suppose we'd better get on with looking at the
let's give some folks some good news, or what I think is potentially some good news, some encouragement. I think we're due to have a bit of encouragement, and let's talk about that.
Sure. Hopefully that's come up for everybody. I think so.
I can see it on my screen, so hopefully
excellent. Yes.
Can.
Yep. It's up.
Okay. So again, it was just very recently filed. I highlighted in green things that were procedural and just kind of information. Yellow, it just came out October 7th, 2020. Again, I found out about it. Julie was talking about the announcement on the cases in the Court of Appeals, District 2. That is the district where Stephen's case is pending. And then the style, what we call the style of the case, the names, is their state of Wisconsin versus Manuel Garcia. It's an appeal. You can scroll down a little bit. So the trial judge was Michael Piontek, and the appellate court reversed and remanded case for a new trial. Wow. So when you see a criminal appeal, the state cannot appeal a not guilty verdict. They can appeal some other things. that we call interlocutory, like if the judge denies the state, maybe the judge quashes an indictment, or maybe the judge grants a motion to suppress. In some state, the state can appeal that. And so, but most of the time when you see state versus somebody, it's a criminal defendant appealing the case. And so I saw at the beginning reversed. It's so rare in appellate cases, criminal verdicts get reversed. I thought, wow, here's something interesting. And then what's real critical is that next thing in green, the 3-judge panel that heard this case were Neubauer, who's the chief judge, and then Riley, who's presiding judge, hears and decides a lot of the motions. In fact, he granted 2 of Zellner's motions to remand the case back to the circuit court. One was on the Brady issue with the computer information. The circuit court judge said, no, I don't think it's Brady, and I'm not going to give you a hearing on this. And Zellner filed a motion with the appellate court, and Judge Riley said, no, you're right. Circuit court does need to look at this and hold any hearings, necessary. Of course, she didn't hold any hearings, and it went back. And then towards December of that year, when Zellner's brief was becoming due, it came to light to Zellner that the state had returned the bones to the Halbach family, and Zellner filed a motion as a result of that and asked that it be remanded. And the attorney general, the attorneys for the state at the appellate level, kind of had some cutesy response that, well, if they want to pursue that, he can dismiss his appeal and then appeal this. And Riley said, Riley wasn't impressed with that argument on that all. And he told them in no uncertain terms he was displeased with that type of argument and granted the motion to remand. So Riley, and then Gundrum was in the legislature, and he was working on the Avery bill. We saw that in MAM 1, and there's going to be an Avery bill about criminal justice reform and compensation for people who were wrongfully convicted. Stephen was in that sexual assault case until he got arrested. But I don't think Gundrum would sit on the appeal. I think he would think that it would give the appearance of impropriety because he worked with Stephen on the Avery bill. But so it would be the 4th judge who you just looked up is Davis, who was appointed by Governor Evers. So we got the same, majority of the same judges that would be looking at Stephen's appeal and determining whether it needs to go back to the circuit court for evidentiary hearings. Zellner also put in her brief, it should be reversed and him found factually innocent, or that the appellate court just grant a new trial. But that's a big stretch. Zellner put that in there just to cover everything, but I think everybody expects that if the appellate court grants relief, it would be for evidentiary hearing, which should have been, held from the beginning. In fact, the state had agreed to look at scheduling evidentiary hearing, and that's talked about it at length in the briefs. But O'Reilly wrote the opinion for the court, and joined in by the other two judges. And again, this legal issue doesn't have any bearing on Stephen's case whatsoever. But why I drew hope and encouragement is that this was what, people who are not in the criminal justice system as lawyers, what have you, this is somebody who got a new trial based on what we all term as a technicality. Mm-hmm. And a technicality is, it's usually a word of derision. Oh, he got off on a technicality.
Yes. Well,
the technicality is that you didn't get a fair trial or your rights were violated. That's the technicality. Yes. So, they reversed this case based on a technicality. And what that is the trial court determined that a confession that was given by the defendant, Mr. Garcia, while it was voluntary, it was not knowing under Miranda. Yep, so a confession has to be knowing and voluntary to be admissible. And, so to be knowing, you read the Miranda rights that we're all familiar with. Even you all in the UK know it. And he was read his rights, but English was his second language.
Sure.
And so his trial lawyer was able to show he didn't give a knowing waiver. So if we scroll down.
Yeah.
So what happened? Trial is, go ahead. Did you, scroll down unless you had a comment or question.
No, it was just, remind us again, CJ is chief judge, Gundrum judge, PJ
presiding
judge. Yeah.
And that usually means that for administrative purposes, they hear a lot of the motions and things like that.
Yeah.
So what happened is the court ruled that the confession's not coming in.
Yeah.
And everybody knew that. Then the trial started, and the prosecutor called the lead detective as a witness, and tell us about your investigation stuff. And then on cross-examination, the defendant's lawyer in cross-examination said, "Well, did you do this? No, I didn't. Do this? No, I didn't. This? No, I didn't." And what they were asking about, there was a non-custodial interrogation.
Mm-hmm.
Wasn't under arrest or anything like that, where they asked him some questions. Mr. Garcia said, well, he did go to the doctor and he had a couple of accidents.
Yeah.
Had one accident, and then he fell out of a car. So those came in, and they were at, well, so did you explore that further? And no. Explore the falling out of the car further? No. And so then the state said, well, we want to play portions of the confession where Mr. Garcia admits that he punched the 2-year-old boy and threw the 2-year-old boy on a bed because they've opened the door. If we scroll down, I'll point out what opening the door is.
A bit further.
Okay, so I'll pause here for a second. So highlighted this because this was a very serious crime. Garcia was convicted of first-degree reckless homicide, and which manslaughter in a lot of jurisdictions, or what we call it in Texas, but that punishable by 2 to 20 years in Texas, that level of offense, if it's reckless. the trial court judge denied his post-conviction motion, and so it went up on appeal. And it resulted in this charge came out of the death of his girlfriend's 2-year-old son, who died of blunt trauma to the head. So those cases, we can scroll down, always have a lot of emotion. They always invoke very strong feelings in the community that they arise out of. We're all familiar with those types of cases, and we think when we read about them in our community or our state. And so, but yet, even though there was a lot of pressure, so to speak, on this appellate court panel, they went with the rule of law. So that's encouraging, even though Stephen's case is high profile and evokes a lot of emotions on both sides. It's encouraging to know that by all appearances, this panel, this court will look at the rule of law and whether Stephen was entitled to evidentiary hearings for his lawyer, Kathleen Stelner. So that was encouraging to me.
Yes.
Scroll down below.
Yeah, I'd certainly with the, the Dr. Michael West and the Stephen Haney guys down there in Mississippi, and you see some of the decisions that are upheld by various courts.
Go back up to the part of green, just up a bit. No, I forgot.
Yeah, sure.
So this is a footnote. And so, again, this case is all about the confession of the defendant. It was excluded. Then the detective was cross-examined, and the state said, oh, it's leaving an unfair impression in the minds of the jurors, because the detective would say, I didn't investigate these other things because he confessed, or he admitted to punching and throwing the child on the bed. So I didn't explore the automobile accident. I didn't explore the other incident.
Yeah.
And so you would think in an appeal like that a DVD of the video, like Brendan's DVD sitting on the couch in his interrogation, it would be important, to know, well, is this a false confession? You'd want that DVD as part of the record.
Sure.
And or a transcript of the confession. And I was telling Millbilly earlier that Millbilly is really good at finding all of these things that are weird. Stephen's case has way more than its fair share of discrepancies and weird things going on. Richard and I used to talk about, well, what number are you up to? And I was told there's 50 things, and what number are you at now? And well, there's another 5 or 10 things. Pointed out, to the point where Finn and Julie did that channel 80 More Things that you've appeared on, and I have, and many, many, many others, talking about some of the 80 and plus things that are unusual. But I highlighted this in green just to show that, weird things happen. Things don't make it in the record, and for a lot of different reasons. And it happened here. The most critical thing you would want, an appeal of this type, wasn't even part of the record. And but they said, it doesn't really matter. We don't need it because the way the issue turned out. We scroll down below.
Sure. Keep going.
Let's see. that's just showing the requirements of,
Sure.
to satisfy Miranda, whether the admissions to police were the voluntary product of rational intellect and free, unconstrained will. Now, that issue did come up in Brendan's case. They said because of the nature of the questioning and so on and so forth, you'll recall, I know you will, Paul, that they, Warren Nyrider argued, well, they broke his will.
Yeah.
They didn't yell and scream at him, but for somebody of that intellectual makeup, that would be breaking their will. And that's what they're talking about, free, unconstrained will.
Yeah.
Okay, go down below.
Yeah. I mean, certainly in Brendan's case, it was just the fact that there was no fight back from Brendan at all. He would never, he just basically agreed, didn't he? He acquiesced to everything that they said. So.
Yeah, he just kind of went along with them.
Yes.
And so this is the facts. The investigating officer testified at trial regarding the investigation. It didn't mention the confession.
Right.
Also brought up that there was 2 accidents a week prior, slipping on some stairs and jumping out of a vehicle.
Yep.
Then on cross-examination, the defense attorney pointed out you didn't do all these things, and then in response to these questions, the state moved the court to allow the officer to be rehabilitated by utilizing Garcia's excluded statements to explain why the officer did not investigate other incidents. And defense counsel's cross-examination in all of these areas, that they opened the door. And what that means is you can go too far. You can get a ruling that says, okay, state, we're not going to let you go into bad on the defendant. Let's say, the defendant had 5 girlfriends or something. It doesn't have anything to do with the crime. That he's gay and has a male lover, and has nothing to do with the offense. But they bring up the defendant as gay, let's say. And then the court says, no, I'm not going to let you bring that up. You're trying to get the jury to convict the person he's immoral or unlikable, not because you go to the offense. You can go too far, and if you go too far and you ask a question that really doesn't conform with the truth, you can open the door, and then the defense is allowed to go into it. And except when it is from a confession that's been excluded, you can't open the door. Scroll down below. Again, this is just background. These issue doesn't match up with anything in Stephen's case. Why we're pointing this out is here's an appeal. The same court that Stephen's case is pending that was reversed on a, quote, technicality, unquote, but that the court, despite the fact that this is going to cause some outrage in the community where it happened, was willing to follow the law, which that is a good sign for Stephen. That's hadn't always been the case in sexual assault cases I've talked about with 3 co-defendants and 2 co-defendants who had the means to hire lawyers came out really good. One who didn't have the means to hire a post-conviction attorney he stuck with his conviction. And anyway, so they showed some of the statements to the jury. Scroll down.
Yep. Yeah. The other thing I was going to say was that obviously, although Manuel Garcia is Spanish, would it be fair? Would it be fair to
presume?
Yeah.
Or definitely Latino. I don't think it's said in the opinion, but
yeah,
I would speculate that Spanish is his first language and English is his second. Yeah.
But would it be fair to say that, you know, when it comes to the Wisconsin public, probably Manuel Garcia doesn't endear himself much to the Wisconsin public because he has admitted to being slightly rough with the child. And there is that similarity whereby, you know, Stephen Avery is disliked by quite a lot of the sort of Wisconsin public because, as far as they were concerned, they got a conviction.
Right. And so, yeah, that's why I draw hope and encouragement from this opinion. And there's the part about language barrier.
Yeah.
So then when they showed those portions of the confession to the jury, the defense attorney said, well, now I have no choice but to put them on. And then Garcia got on the stand and explained, probably through an interpreter, that he didn't understand the difference between the word punch and spank due to English not being his primary language. And scroll down.
Sure.
And then the jury, despite that testimony, found him guilty of first-degree reckless homicide, and he received a lengthy prison sentence. I don't know what the term is. I'm guessing 20 to 40 years.
Sure.
Don't know, but lengthy. He filed a post-conviction motion with the same judge. Said, look, I know you ruled against us during trial, but I found all this law, I want you to take another look at it. As you've pointed out, it's very difficult, not impossible, but it's very difficult to get a judge, any human being really, who's made a decision to reverse themselves.
Yeah.
It's a rare feat, but so some people question whether post-conviction motions right after trial, we call it a motion for new trial in Texas, but if the trial court who denied you anyway, whether they should be the ones ruling on it. But that's the system we have. The trial court said no. I'm going to stick with what I originally cited, and Garcia, through his appellate lawyer, appeals to the Wisconsin Court of Appeals to scroll down.
Yep.
And let's see, what do I have here? Garcia does not reassert his ineffective counsel claim. So he did, in his post-trial motion, he said ineffective assistance of counsel for opening the door. And number two, the trial court erred by letting in portions of the confession, which had been excluded under Miranda. And on appeal, they did not raise the ineffective assistance of counsel claim. Dellner, although she has a lot of issues up on appeal, she did not raise a couple of issues on appeal. For example, prosecutorial misconduct. She did not. She had in her motion for post-conviction relief, not her appellate brief. The brain mapping, she had in her motion for post-conviction relief, not on her appellate brief. So just like in this case, those issues will be considered waived. And no big deal to that. It was done on purpose. Just didn't feel there was much or any merit to those arguments. And so
Sure.
why distract the court? We have so many good issues to talk about. So they ordered supplemental briefing and scheduled an oral argument. I already talked before about how rare it is to get oral argument in a Wisconsin Court of Appeals case in District 2. And what drew my attention to this case back earlier, his original appointed attorney withdrew for good cause. I don't know what that was. He may have gotten sick.
Yep.
New counsel was appointed. Due to the pandemic, oral argument was delayed. And then after reviewing the supplemental briefs, the court said they didn't need oral argument. So, and again, Zellner has asked for oral argument. The state said we don't need oral argument. The court hasn't indicated whether they're going to order oral argument or not. But it was important at the time because if they do order oral argument, it's going to affect the length of the case. When you know have the oral argument first, then they have to decide the case, which is a completely different timeline if there's no oral argument. We can scroll down.
Sure.
So here I put this in red box because it's important. Yeah. So despite this tragic case, this emotionally charged case, a possible desire by a lot of people involved at court take a blind eye like the trial court did to this constitutional violation. This court said no, we're not going to take a blind eye, or we're not going to create an exception that doesn't exist. We're going to enforce this long-standing rule of law that do not allow the use of the confession that's been excluded to rehabilitate the detective. Scroll down below.
Yeah, I must admit, it took me a while to realize what the term rehabilitate was referring to.
So in the drug use context, if you get off of drugs or alcohol, you go to rehab.
Yep.
If you've hurt your leg or broken your hip, you go to rehab to either learn to walk again or get back as much function as you can in your limb. In a legal context, if your witness has been impeached or effectively cross-examined, what we call the redirect is where you try and rehabilitate the witness. Okay, keep going down.
Sure.
We'll find the next highlight. Okay. So they talked about here that the state and the defendant's counsel in the brief, they didn't really understand the standard of review. They thought it was the standard for a discretionary ruling, which is much higher than a constitutional violation. And then they are just pointing out here that, look, we see it as constitutional grounds, and that's how we're deciding it. Doesn't matter that neither side argued standard. But it's interesting that the defendant's appellate counsel didn't argue it as a constitutional violation, but they're saying it doesn't matter. We can apply the standard. We have enough facts. Scroll down.
Sure.
So, that would have been maybe a possible out for them, appellate court, to say, oh, well, they argued at that standard, we'll just go with that and just say you don't meet the standard. But no, this is a constitutional violation and we're going to apply the right standard. So here, paragraph 16, the state's saying, okay, yeah, everything is right about that. You're not supposed to be able to use voluntary confession. What they're urging the court to do is to create new law, create an exception. No harm, no foul. And why I put that in green is that, the analogy in the Stevens case is that Gellner set out that clear law when you're entitled to evidentiary hearing. Very far. I don't think anybody disagrees that Gellner met that.
Yep.
Even way exceeded it. The state's, relying on this procedural bar, this procedural argument. Well, you don't need to get there. It's all barred anyway.
Yep.
And they made a halfway attempt to try and argue why you don't need evidentiary hearing, but here the court saying, no, we're not gonna create an exception. No, we're not going to look at it and say, oh, no harm, no foul. He was entitled to an evidentiary hearing. He's going to get an evidentiary hearing. That's why through encouragement from this opinion. Scroll down.
Sure.
So, conclusion, circuit court erred in admitting Garcia's statement. Their meaning is portions from the video where he admitted to punching and throwing. And he's entitled to a new trial. And then scroll down below.
Sure.
And here the court says that not only are we willing to reverse this case for a new trial, we think it's important that it be public, and we recommend publication in the official reports. Those are the bound volumes. And then Wisconsin, as I learned after I got in this case, the help with Tracy, in some jurisdictions you can cite to unpublished decisions. You just need to let them know that they're unpublished. Not so in Wisconsin. You cannot refer to an unpublished decision at all. So it's a big deal. Cases get published. A lot of times courts feel like, well, we're making the right decision, but I don't necessarily want everybody in my district, where I'm running again for election, and it may be at a subconscious level, but Justice Scalia talked about in an opinion that we're going to do this opinion, but I feel like we should be doing it with bags over our heads when we announce the opinion. And so all Supreme Court opinions for all public, not in the state court. So there's several things I took from that decision that I think supporters can find encouragement and remain optimistic. I truly and sincerely believe that court is going to give Zellner's appeal an honest look.
Yeah.
And may not come out the way we all want, but
Sure.
This really helped me seal in my mind that, and agree with Zellner's tweets, that this Court of Appeals is going to give an honest, decent, fair shake to the appeal.
Yeah.
So,
is that a case of we really should applaud if almost the bravery of these judges to to go with this this and say, yeah, we're not going to turn a blind eye to this. We are gonna address the issues that have come up, and we're going to do so fairly. And I just wonder if there's any sense that the eyes of the world are on Wisconsin because of making a murderer, and whilst you don't want the judges to be influenced by popular cult TV goings on, they are human, and whilst we applaud their bravery,
yeah,
is there a possibility that they've thought, well, we're going to do this right. We're going to get, if the law says you can't do this, then you can't do it. And
yeah, I really appreciate the way you worded that just a minute ago. I'd like to hope that judges don't have to be brave to rule correctly, but in fact, depending on what your angle is, that's exactly what you need them to do. If they're always worried about, well, how's this going to look? A case from the total opposite spectrum is that Stanford athlete in California who was convicted of some sort of sexual assault and was given probation, and they did a petition for recall and recalled that judge, unelected that judge, threw that judge out of office. That's an option that they have in California and a lot of states. That's one of the big differences between the federal and the state system. Nearly all states, state judges are elected. Federal system, you're appointed for life. Both have pros and cons. But, they do things like, when it's a judge, they make it nonpartisan. You drop the party. But I guarantee you everybody in Wisconsin knows what Gundrum's political affiliation and party affiliation was before he became a judge.
Sure.
I mean, everybody knew on that Supreme Court race in Wisconsin between Neubauer and who was the other one?
Oh, Bungenhagen or something like that.
Yeah,
Bungenhagen.
That what his position was on very conservative issues, and it comes into play. We have Supreme Court appointment right now, and it forced a lot of political ideology is at the center of the appointment of Supreme Court, because they are lifetime appointments. But no, we hope that judges are going to look at the case based on its merits, not what the community might think. You know, I don't think there would be any community I can think of where Mr. Garcia would have a huge fan club. And the more conservative of an area, probably the only people on his side would be family, but and I can guarantee you the mother of that 2-year-old is probably in the camp with the prosecutor's office and the AG's office that have victims of crime. The prosecutor says, "Oh yeah, we got this confession and we got this and you're going to go with what they tell you." But despite all of that, despite the state arguing, "Hey, this is a terrible, terrible case," and implying, you reverse this case, this guy might go free. And it shouldn't matter what the crime is, whether it's a DWI, jaywalking, speeding. The standard should be state reasonable doubt that comply with the defendant gets a fair trial, that his constitutional right not be violated. Whether it's a capital offense in Texas, they don't have that in Wisconsin, but whether it's murder or capital murder where you might get the death penalty, or writing a bad check or something where you might get a fine, the rule of law has to be consistent. And what frequently happens, and it's been discussed in Stephen's case, that the more serious the offense, sometimes say, "Well, don't want to take a chance, so we'll let them fix it on appeal." Most people on the jury and most people aren't directly involved in criminal justice system don't realize, as you all know who are supporters and follow the case, that because the doctrine of finality and whatnot, the burdens flip-flop, and it's very hard to fix something on. Very, very difficult to fix something on, as we're seeing.
Indeed.
And so you got to, sometimes juries will say, "Well, I'm not really sure, but really don't want to take the chance to having that guy back out on the street. Let them fix it on appeal," and so they lower the standard of proof beyond doubt. And we're seeing, because of DNA, that juries did that a lot. We go back and see the evidence, witness ID, identification evidence, which is the least reliable, and Stephen's case. Oh yeah, I'm sure it's this guy that's proven beyond a reasonable doubt, no, it wasn't the guy. And but as between this defendant and this poor innocent woman, upstanding woman, business owner in the community, it's hard to say. I know all of his family came in and said he wasn't even in town. He couldn't, or whatever, couldn't even have done it. I just better not take a chance. You see it over and over again. And then we've seen it with taking baby case to the science, just terrible, and a lot of junk science. And then, to their credit, a lot of these experts who testified against parents or boyfriends or caretakers of children that testified oh yeah, this finding on an X-ray, an MRI, or a CT
Yep.
is definitive for shaken baby syndrome. And then they, to their credit, science evolved and got better. And it's like, no, you could have this finding in a perfectly normal baby with no trauma. And they sign an affidavit, it's taken to a judge. Look, I testified to this, but the science has moved forward and my testimony is incorrect. And they've reversed cases all over Texas.
Sure.
Taken faith.
Yep.
But yeah, no, it's so I don't know. Do you find anything encouraging in the opinion we just went
I
through?
do, yes. Yeah. It's exactly the same thing, that, you know, the ends don't justify the means, and if things are done wrong, then they're done wrong. And you know, what was the term you said? No pain, no foul, or something like that.
Oh no, no harm, no foul.
Yeah. Yeah. Well, you know, there was a lot of harm done in this case to Stephen. So yeah, as I say, I'm encouraged by the, for want of a better word, the bravery of the judges to say, you know, no, you're not going to carry on like this. We're gonna sort of begin to clean the swamp out, as it were, you know.
Mm-hmm.
And I hope that Angela Sukovich has looked at this case and said, I could be in trouble here.
Yeah, and then, you know, if it did get sent back for evidentiary hearings, she may just decide to, you know, wash her hands of it.
Yeah.
Okay, you know,
I've done my best.
it came to me because the judge in Manitowoc had a conflict, and so it was to me.
Yeah.
They're asking it to be sent back to Manitowoc because they have a new judge, wasn't involved in any of this stuff, but I've got to hang on to it till at least this point, you know. You may just say, no, I'm gonna bounce it.
Yeah.
Or maybe not. But I have seen where judges have been overruled by an appellate, and it come back to them, and they just turn into a completely different judge. They bend over backwards the other way because they don't want to be reversed twice. And so we'll see. The other thing I just realized is that if they don't order oral argument, this case was pending, but just before the pandemic got delayed because the attorney withdrew. Good cause. I don't know what it was, but this case moved forward from March to October, despite the fact that you know, a lot of the courts, certainly the trial courts, are shut down or slowed down. But you know, it went through, and they've got an opinion out, and the things are progressing despite pandemic. So one thing we know is that appeal is going to be moving forward. Now, if they order oral argument, then we just may wait to see how they're doing that. The Wisconsin Supreme Court is handling oral argument by Zoom, as is our court here in Texas and appellate court. And, you know, there's pros and cons to that. It's just difficult to read judges through a screen. Either, you know, you have a better feel for body and stuff from judges, and so, but you know, there is that possibility of allowing it forward. And the nice thing about these video conference oral arguments is that they're available live in real time. If we'd all be able to watch, unless I get, I know some of these platforms like Zoom and WebEx, whatever, have limits, and depending on what level you get, 100 viewers or not, but maybe they would make a competition for that. But in any event, it's going to be available, and I'll be able to see it. So things are progressing, and when the facts and the law warrant, in that court, at least they'll stick to the rule of law, no matter how heartbreaking the case. Death of a 2-year-old child, apparently at the hand of abuse by boyfriend.
Yep.
So if there's some, it's like talking about musicians earlier. It's like opera. You have opera buffa and Marriage of Figaro, lighthearted, and you have opera Sarah, the tragedies of Otello, or some Wagnerian opera. I love opera, but you have to look at the tragic death of a 2-year-old in order to gather encouragement and optimism in our case. But I think everybody understands the spirit in which I was trying to analogize the two cases.
Yeah, I think actually Alice Irvin has summed up very, very well in response to one of the commenters. She was asking, what is the good news? And Alice has pointed out that the District Court 2, which is reviewing Stephen's case, is looking at cases fairly, which will go good for Stephen, maybe getting an evidentiary hearing. So, yeah, that's very, very, very succinct.
Very, very well put.
Yeah.
Yeah.
Trav,
I guess it's because, a lot of the comments and the social media things that we all belong to, not really the host of the channel, but, a lot of the supporters, this constant theme of there's all this corruption. And the words thrown around loosely, and, depending on what your definition of corruption is, there's certainly more than its fair share in this case. But Zellner has said in a tweet that she's perfectly confident in this court looking at the case. And so, you kind of just keep hearing that, Wisconsin's so corrupt, this and that. And then people start to worry and, or they start maybe to, whatever, but they, it's nice to see an opinion like this where Ellis, very aptly points out that this court, where his case is pending, will look at a case fairly.
Yeah, and that's all that we want. We just want a level playing field.
Mm-hmm.
Yeah.
So you can, there may have been corruption up to this point, whatever, but we can move past that and we can focus on, what are the arguments that, what's the court going to do with this? And we know that cases are progressing despite the challenges that pandemic caused all across the country in courts everywhere.
嗯哼
Yeah. Now, I wish it was, something more direct.
We'll save that one for next week.
Just a decision on it. I'll take anything. The similar thing happened with the Wisconsin Supreme Court, which you actually jumped on early, if I recall, Paul, on what I pronounce as the water ski case. I think it's Watursky. I'm still getting it wrong, but a major shift in the way Wisconsin was going to look at Brady violations. Yes. And instead of casting this burden on the defendant to show, it's like, look, Brady's, if you ask for it and it's exculpatory, you got to turn it over.
Yeah.
Why are we even looking at the conduct of the defendant, or whether this stuff rises to a level, or that you show misconduct on behalf of the prosecutor? Brady says if it's exculpatory and you ask for it and you don't produce it, it's a constitutional violation.
Yeah.
Which that Wisconsin, the Supreme Court, they got out in front of it. And that was encouraging because that's a conservative court.
Yeah.
And it's even more conservative now after the last round of elections to the Wisconsin Supreme Court. And yet they have, depending on how you look at it, struck a blow against prosecutors hiding the ball.
Yes.
And are telling prosecutors you're going to be held accountable if you hide the ball, and that you can't gamble and hope that we'll say, well, yeah, technically it's a Brady violation, but didn't hurt your guy too bad. We're not gonna do that anymore. We're gonna. I don't know. I don't think you've seen our new addition. This is Buddy.
Hi, Buddy.
And Buddy is a UK original. He is a fox terrier.
Right.
He's about 8 weeks old right now, and he'll grow up a little bit more, his paws, and he'll keep all of the foxes at bay.
Excellent. Well, listen, Travis, you go and enjoy some quality time with Buddy, because it's been absolutely great to have you on. Brilliant stuff. Thank you so much for your message on the early hours of Saturday morning. It was for me. And yes, I think the fact that so many people have tuned in to see what you were and hear you talking about this particular case and its implications for hopefully justice returning to some of the places where maybe it's been hiding in Wisconsin. It bodes well, doesn't it? So
and that's the whole reason why I shot you the note, is that while we're waiting for this,
exactly, it sets the mood, doesn't it?
We are due for a little, short of the opinion coming out, and the opinion coming out the way we want it. But short of that, we are way overdue for a bit of encouraging news. And when I was reading through it, I felt encouraged and wanted to share it with people. I know it's not near what people are ultimately hoping for, but I think there's plenty to be optimistic about.
Absolutely. Well, I'd like to thank everybody that's tuned in, but as I say, particularly big thanks to Travis for all your work. Much appreciated. We'll keep in touch, and as you say, let's hope it's not too long before we get some good news further good news with Brendan's case. I'm gonna say cheerio. If you'd like to say cheerio.
I'd like to say goodbye from me.
And it's goodbye from him. Thanks, everybody. Cheers, Trav.